This is Earl White, real estate attorney. This is a video about earnest deposit contract provisions. We're going to cover what is a deposit, what are the key elements of a contract provision dealing with deposits, and what are three critical considerations as buyers and sellers to a real estate transaction in negotiating the different elements of the contract. So first, what is a deposit in a real estate contract? The deposit is money paid by the buyer in the beginning of a transaction, typically within 1 day upon signing to 10 days in most cases. And that money is held in escrow, often by an attorney for the buyer, an attorney for the seller, an escrow company or a title company that's contributed towards the buyer's down payment and closing costs when we get to the closing, or released to the buyer upon proper termination of the contract. And if we get to the closing, it's given over to the seller. So that's generally what a deposit is in a real estate transaction. So with that in mind, what are the key elements when you are drafting this contract provision? What needs to be covered? First, most obviously, the amount of the deposit, so the amount the buyer has to make. Second, the time frame for the deposit. Third, who is going to hold the deposit. So typically that's going to be the attorney for the buyer, the attorney for the seller, a title company, whoever the parties can agree to that they can trust to hold and administer the deposit properly. And also the conditions for the release of the deposit that needs to be spelled out. What's going to happen at the closing, what's going to happen upon a termination, and all those things need to be negotiated and placed in the contract provision. Now, what are the considerations between the buyer and the seller when they're negotiating this provision? Because the intents of the parties tend to be opposite. The seller, on the one hand, wants to negotiate for the highest amount of the deposit possible because the deposit is going to show that the buyer's committed to the sale, and also keep them accountable, because if the buyer is going to breach the contract, the seller is not going to make it easy for this sum or all of this deposit to get returned to the buyer without some sort of penalty. Vice versa, the buyer wants as little a deposit as possible, because if the seller's even if they're acting properly and the seller is unreasonably withholding or failing to consent to the return of the deposit, the buyer's then going to have more money stuck in this escrow account, which typically, if the parties don't come to an agreement, the escrow agent can't just freely give the parties money, so typically it may have to go to court for release of the deposit. So better for there to be a small amount of money at issue for the buyer, so there's less liability for them. And also the buyer, typically, not just that, if they do have to cancel, or we have contract provisions that prevent the buyer from canceling, and the deposit, say, has to go to the seller first as part of negotiation, then the buyer wants a smaller amount of money to go to the seller. So what's the negotiation power here? If the seller has if it's a multi-offer situation, then the seller can sometimes call a shot as to how high the deposit be. They could play the offers against each other to say, look, whoever is going to make the largest deposit, who's going to make a serious deposit, we're going to go with them because more likely they're going to perform and close. Also, if the seller's not that motivated, like they would like to sell, but they want to feel confident before spending time on it, then sure, they might hold out for a higher deposit. For the buyer, they have a lot of leverage when, again, they're not highly motivated to purchase it. People wouldn't be involved in the transaction if they're not motivated, but they might say, hey, look, we could have other offers out there, so we're not going to put ourselves locked into one property at this amount of money to limit our other opportunities, or we just don't want to take the risk on a specific property because they may not like it enough. Then obviously if the buyer, for some reason, buyers sometimes can't perform. There could be a reason they can't perform. So if they truly can't perform, even the seller being quite reasonable and the parties agree, that's a lower liability that they might get stuck with. So that's the amount of deposit. Now, another consideration to negotiate between the parties is who's going to hold the deposit. Now, typically the seller may naturally feel they want the seller's attorney to hold the deposit because they feel like, okay, look, that means as my guy holding the deposit, I feel more confident this deposit was made and there's no fraud involved. Vice versa, buyer probably wants their attorney or their title company to hold it because they don't know the seller's attorney and they want to make sure their money is being dealt with properly and not going to be transferred to the seller illicitly or inappropriately. My personal recommendation is to have the escrow agent or title company hold the deposit, not the buyer's attorney or the seller's attorney. A few reasons for that. One is that the law, if drafted, the contract, if drafted properly, whether it's the buyer holding it, the seller's attorney holding it, a title company holding it, an escrow agent holding it, regardless of who's holding it, the rules are going to be the same. The parties can't just transfer it to buyer or seller, and if there's no written agreement, then it's going to have to go through the courts, and that should be drafted in that nature. Unless it's special negotiations, then put aside special negotiations, then it doesn't really matter who's holding it. And if there is special negotiations, it still shouldn't matter, because we basically have something in writing laying out what has to get done, and whoever's holding it should abide by that agreement, assuming there's no dispute among the parties. In addition, I think the title company is the better play, because wire fraud is a serious concern in real estate transactions for years now. And the title companies, because they handle deposits and loan funds and various sorts of money much more frequently than attorneys, part of their whole business is being the settlement agent. Particularly in New Jersey, like I know states are different. Massachusetts, very different. Florida only has title companies. Massachusetts only has attorneys. New Jersey, where I am, we have a split. We have attorney review. You have multiple parties involved. But nonetheless, the title companies, particularly where I am, they have cybersecurity insurance. They have crime fraud insurance. And they're just handling deposits on a regular basis. So why take the risk of a law firm that doesn't consistently hold deposits as frequently as title company, does not have the cybersecurity and insurance protections that the title company has? Why the parties are more safe and more secure by being protected for security reasons, rather than worrying about, is the other party making the deposit, or is the other party making the deposit? And typically, look, if it's a trustable party and not a third, if we feel you can negotiate that it's an attorney, a licensed attorney, you get a letter on their letterhead. 99.9% of the time, the attorney's not going to be playing games, because their license is on the line. Recommendation: title company to hold the deposit. And last thing for negotiate between the parties is the grounds for release of the deposit. Now, this is very important to both parties. So for the buyer, typically, you have contingencies: inspection, due diligence contingency, mortgage contingency, appraisal contingency, seller delivering you a clear title contingency, and you want to have those spelled out in the contract, and particularly that the deposit, if you have to exercise those contingencies, that the deposit is released to you. So you want those to be as broad as possible for the release of the deposit. Vice versa, seller, they're going to want to limit your inspection. They may want you to waive your mortgage contingency. If it's cash, there's none, and they may even want you to waive it, even and agree to a deposit release, possibly, even if you're getting a mortgage, just because they feel like, hey, you can't perform, give us the deposit, or some kind of penalty, or just if you don't perform, we're expecting you to move forward, be in breach of contract, in which case they can pursue other remedies. The seller may also want that, because the seller may also want to limit the contingencies, because they're making other plans and commitments, so they want to be confident this buyer is going to perform. And if they limit the grounds for the release of the deposit, it's going to motivate the buyer to perform, and it's going to prove the buyer is capable of performing, because otherwise, if they were playing games, they're not going to sign up for a transaction that is set up to have limited rights for release of the deposit unless they feel like they're going forward.